Thank you, welcome, and thank you so much for joining us for the final webinar. I can't believe we are already at almost the end of summer for the final webinar in our special asset summer school series. This session will cover the topics of collections, foreclosures, and workouts, along with a special guest speaker and topic that I will let him introduce himself. I'm Haley Upton Cook, the marketing coordinator of events and proposals here at Ward & Smith, and I'm going to be your moderator this afternoon. If you have any issues with video or Zoom quality during the presentation, please reach out via the Zoom chat feature, and I'll try to troubleshoot with you. Our speakers are happy to take questions during this webinar. If you have a question, please type it into the Q&A box, and it will be addressed at the conclusion of the presentation. There may be an instance where we are able to address it on the spot, but more than likely at the conclusion. I'm going to go ahead and turn over the mic to Norman Leonard, one of our creditors' rights attorneys here at Ward & Smith.
All right, thank you, Haley. Good afternoon. For anyone that doesn't know me, my name is Norman Leonard, and I've been practicing creditors' rights law in Ward & Smith's Asheville office for about 13 years now. I'm joined today by my colleagues Michael Parrish and Lily Faulconer, who will tell you a little bit more about themselves as we move forward with the program. For a couple of summers now, we've been putting on these webinars to highlight new or hot topics in the field of special assets and to refresh ourselves on some of the more fundamental concepts that impact our day-to-day management of special assets files. And today we have a little bit of both. Michael Parrish is going to begin by talking about the increasing prevalence of wire fraud, which is a fairly hot topic right now. And then Lily and I will review some of the fundamental concepts and considerations to keep in mind when reviewing a credit file, deciding what to do about a default, and working with outside counsel to enforce your rights and remedies. As a disclaimer, our discussion today will be necessarily limited to generalities. This presentation is certainly not legal advice, and you should definitely seek the legal advice of your own counsel and discuss with them all of the facts that might be relevant to your own particular situation to understand your rights and remedies. To the extent we discuss any legal rules or concepts today, our discussion is generally limited to the law of North Carolina, and the law of other states may be and often is very different. So with that out of the way, I'll go ahead and hand the program off to Michael Parrish to discuss wire fraud.
Thanks, Norm, and hey, everybody. I'm pleased to be talking today about wire fraud. Norm and Lily asked me to contribute to this webinar because wire fraud is something that we're seeing with an increased frequency here lately, and I expect that will continue over the next few years and maybe beyond that. So what I wanted to talk about today is sort of what is wire fraud, how are we seeing it in the context of disputes and litigation, and what the legal standard is that we're seeing, and frankly that issue is evolving. I find it interesting. I always, when I see these, I see ways that it could have been prevented. So I want to be thinking about that as well. So let me jump in. So what are we talking about when we're talking about wire fraud? I'm certainly not the expert on how this happens, but from some experience, I've gained some understanding. So we've got a hacker or a threat actor, they're called sometimes, an unauthorized user will send a phish email. We've all seen these emails that are either really suspicious or sometimes really good. But the goal is to get you to click on a link that is not legitimate. Clicking on it or responding to the phish email allows the hacker to gain access to your email account, or maybe beyond, allows the hacker the ability to impersonate you or your email account. And the hacker can then use that access to monitor emails and hunt particularly for somebody who is either sending money in or out of your organization The most common scheme that we see is the hacker then sending a request for a change in wiring instructions, saying we've had a change, we're at this new bank, wire the money here, send the payment here, and of course it's not a legitimate account, it's an account that the hacker has set up. If someone falls for it, then the money is then sent not to its intended destination, but to the hacker's account, and the hacker usually takes that, closes the account, and goes on. There are sort of criminal and other like FBI and SBI remedies that you can pursue if you're the victim of a wire fraud, or if your money that was intended for you is subject to a wire fraud incident. Be aware of that, but that's not the subject of this discussion. You have to really act quickly in order to empower those state agencies to try and seize funds before the bad actor can take them. In the instance of an intercepted payment or a misdirected payment that goes to a hacker, the question always is, who bears the risk of the loss of that money? Does the person that sent the money to the wrong place bear the risk? Do they have to pay twice? Is the person who intended to get the money just out of it and not entitled to pay it, or not entitled to receive it? Is it always the person that's gotten hacked? Are they the ones that are responsible? And I'll talk with you about the legal standard that is evolving across the country on that in just a minute. I know, by the way, that most of you deal with getting money in from your borrowers or debtors, and not necessarily in sending money out. But this discussion pertains to you for a number of different reasons. Well, the first is that it's everywhere. You may see it. You may see the phishing attempts come to you because if you work at a bank or a financial institution, you're not immune from this. There are various examples of banks being compromised as well. It affects you because your customer may have sent money that may have been intended for you to a bad actor. So be aware, even if you're not the ones wiring out the money, you still may be involved in this type of a dispute. Let me share sort of a real life example. I've changed it just enough, I think, but I think it's helpful to use a real life example so that we could think about how the legal standard applies in this case. So here's a real case that we're involved in with the facts changed, I think, just enough to keep anonymity. So a bank has a contractor that it's hired to do some renovation work at one of the branch locations. The contractor has an accounts payable person who's in charge of, or excuse me, the bank. The contractor has an accounts receivable or accounts payable employee. That person gets hacked. So we've got a hack that occurs at the contractor. The hacker gets access to the contractor's email and sends a request for the bank to make all further payments to a new account. And this is a really good looking email. It is from the actual account of the contractor's employee with whom the bank has worked in the past. That's the case because the hacker has obtained access to that email account. The bank says, in accordance with its procedures, we actually need to send you a security email. And you need to respond to that. And we also need a letter from your bank with the bank information. So because the hacker has full access to the contractor's email system, that's no problem. The hacker can respond to secured emails, and the hacker quickly creates a fake letter from the bank and has the account information where it wants the new payment to be sent. Payment comes due in a couple of days, and the bank wires the money, a substantial amount of money, six-figure payment, to the hacker's email or to the hacker's new bank account, following the directions received by the contractor's email. Couple of days go by, and the contractor contacts the bank officer and says, "Well, you know, are you unhappy with the work? We didn't do a good job. Can we get the payment in?" And the bank says, "Well, we paid you. We're great. The work was wonderful. We paid you. We sent it out last Thursday." And both parties realize at the same time that they have been the victim of wire fraud. So we'll kind of use that real life example to go forward on the legal standard of who bears the risk in that case. The bank has wired more than $100,000 out. It doesn't want to pay twice. The contractor needs its money, and it hasn't received it. But the contractor was hacked, and a request for a change in payment came from the authentic contractor email. So what do? We're dealing with a number of these situations now. And like a lot of things in technology, it takes our court systems some time to catch up. And I will say that North Carolina has not quite caught up yet, although I think if we allow a few years, we will be. There's not a North Carolina reported decision from our courts about how this would be handled within our state under North Carolina law. Fortunately, though, there is a body of case law, court decisions from other courts, even circuit courts, that have pretty uniformly addressed how this is handled. And the standard is that the party who is in the best position to avoid the risk is the party that bears the loss and has to pay. That is a fact-intensive legal standard. For the lawyers that are on the call, it's problematic to some degree because it's not one that lends itself to an early dispositive motion or even to summary judgment. It's one where a fact finder like a judge or jury would weigh all the facts, look at who was acting responsibly and irresponsibly, and determine who bears the most risk in that instance. It's not always the party who was initially hacked who bears the risk and who has to suffer the loss. That's been made clear by many courts. Many courts have noted that even sophisticated companies and businesses and even the government with very state-of-the-art defense mechanisms are still falling victim to hacks. So it is not as simple as saying you were hacked, the hack occurred on your end, and so you're responsible for this problem. The inquiry does not end there, although that's certainly a factor. It would be a big factor if the party who was hacked did not have a sufficiently sophisticated defense mechanism. It would be a factor if the party who was hacked fell for a pretty obvious dead giveaway phishing attempt. But I think, as we all know on this call, some of the phishing attempts are actually very good. And so it isn't as easy as saying you fell for it, and so wouldn't have happened but for that. And so we end the question there. The reason is because there oftentimes are red flags that occur on the other side. When the request comes in to change payment instructions, that should be an inherently not suspicious, but that should be a request that is elevated procedurally. And I know that a lot of you on the call likely have a set of operating procedures that you or your business implement when you receive a request like that. When someone requests that you change payment instructions or that you include a new account or gives you wire instructions, the most common standard operating procedure is to pick up the telephone, use a known phone number, and to talk with a person that you know to verify those wire instructions. Courts across the country have referred to that standard and have held parties responsible for a breach, even if they're not the party that's been hacked, if they aren't following that standard. If they aren't picking up the phone to verify new payment instructions, they're being held responsible for the loss. On the party that's receiving the request for a change could also be held responsible if they did not act reasonably, not only in failing to confirm, but also in failing to pick up on some red flags or dead giveaways, such as perhaps wiring to an account that's located across the country, seeing a name that doesn't belong, seeing an address that doesn't belong, seeing something that's out of place and inconsistent with prior dealings with the other party. So all of the facts get thrown into the hopper and would be evaluated by a fact finder to determine who is best or who would have been best able to avoid the risk of loss. And that party would be determined to be responsible. Thinking back to our real life example here, where we have the contractor who has been hacked and sends the payment instructions and request for a change to the bank, the key factors would be, did the contractor have appropriate safeguards? Did the contractor fall for an obvious red flag in the fish? Did the contractor take appropriate actions when it found out about a hack? And then from the other side, from the bank side, the party that issued the payment would be, did they follow their own procedures? Was it adequate for them to just require the sending of a secured message? Was there a phone call to verify the payment change? Was there any other red flag or dead giveaways that this was out of the ordinary? Did we proceed with paying the money in the face of something that should have told us not to do so? So all of that gets thrown into the hopper, and the court would decide who bears the risk. On our facts, the case is in its early stages, and so the court hasn't decided. I've obviously left some facts out, but there are more that would go in favor of one side or the other. Lots of facts and lots of forensics to determine how the hack occurred, what emails were sent, what communications were had, and who should have done what. These types of cases would also involve expert testimony about what the standards are. I think there are standards within the banking industry, and regulators and agencies might require certain standards and protections. So in our facts, if, for example, the contractor was determined to be the responsible party or the party who could have best prevented the loss, then the contractor doesn't get its money. The contractor has to bear the risk that its money got sent somewhere else and it doesn't get it. If, on the other hand, the bank was determined to be the party who could have best prevented the loss, then the bank has to pay twice. So those are the items that we're looking at being litigated. I want to mention another provision of law that's of some interest to banks and came up recently in an interesting decision. It's Uniform Commercial Code section 4A-207. I never want to be looking through Article 3 or 4 or 4A of the Uniform Commercial Code, but sometimes we go there. That section talks about what responsibility the bank that receives the wire might have in this type of a situation. If a bank receives a payment order and the receiving bank knows that there's a conflict or a difference between the name on that wire and the name on the account identified on that wire, then the receiving bank, the bank that's receiving that wire, has to return the payment. If the receiving bank pays it and it knew of the conflict between the name of the beneficiary and the name on the account, then the receiving bank can be liable to the party that sent the wire request. So That played out recently in a Virginia federal court, Studco Building Systems versus First Advantage Federal Credit Union. And what was interesting about that case is that the wire transfer was sent, or the wire request was sent to First Advantage Federal Credit Union. There was a discrepancy between the beneficiary name and the name of the account where the money was to be transferred. First Advantage didn't actually know, didn't have a human review this, but it did have a software program designed to pick up on that conflict. That software program triggered an email alert, but no one monitored the email account to which the alert was sent. And so First Advantage said, we're not caught up in this because we didn't actually have knowledge. The court, though, said, your security system told you. And so that was sufficient for knowledge in that case. And under those facts, the First Advantage, the party that paid on the wire transfer, was the bank that actually had to bear the risk. So there's a lot of generalities in this discussion, very fact intensive, evolving a lot of times. And again, nothing really in North Carolina that definitively tells us how our courts would handle it. But because we are seeing it so frequently, Norm and Lily wanted me to go over some of the basics of wire fraud and how it comes to our attention. I did want to open up for any questions that any of you might have about anything that I've mentioned. Okay, well, if no questions, then I'll just turn it back over to Norm. Thank you, guys.
Thank you, Michael. All right. Okay, so we're going to go ahead and move on to the second part of the presentation. And Lily and I are going to talk about the steps that one takes in wrapping their arms around a collection, foreclosure, or workout, and the basic steps that you want to take. As a special assets officer making a decision about how to proceed with a file, you likely have a number of considerations and procedures that are specific to your own institution. But from our vantage point as outside counsel, this is essentially the thought process. And that's that you want to assess the loan documents. You want to understand any deadlines that might be looming to take action. You want to consider your collateral position and then work from there to formulate your preferred strategy. Next slide, please. So the first step is to assess the loan documents. And here you really want to make sure that your file is complete. Missing loan documents can lead to incorrect conclusions about your rights and remedies and when you might have a deadline looming. For example, if you have, if there are releases of collateral or releases of guarantors that are missing, you might think that you have certain remedies and certain collateral that you don't. If you are missing any note modifications or loan modification agreements, then that can lead to incorrect conclusions about what your deadline to take action is. And from there, you want to ask yourself whether or not the bank is likely to have the original loan documents stored in its vault. And you want to confirm, among other things, that you have the original promissory note. Missing promissory notes can cause problems for, in particular, assignees of loans. In North Carolina, some of our Uniform Commercial Code provisions are older and have been updated. UCC Section 3-309 is one such provision. That's the provision that defines the circumstances when a lender can enforce a lost promissory note against the borrower. In a lot of states, it's a fairly lax standard. Or not lax, but it's a pretty broad standard. In North Carolina, however, if a promissory note is lost, the current case law holds that only the note holder that lost the note when it was in their possession, has standing to enforce the note against the maker. A subsequent assignee of a lost promissory note may not have the ability to sue the borrower under that note for collection. And there are a number of caveats to this rule. First of all, for example, the fact that an original note is lost may not affect an assignee's ability to sue on a guarantee, because that is typically going to be considered a different contract than the related promissory note that guarantees outside of the UCC. So the provision applying to lost instruments won't necessarily apply to a lost guarantee or an original guarantee. Similarly, that rule may not apply to the enforcement of a deed of trust that secures a lost note, because again, the deed of trust is outside the scope of the UCC. There isn't any case law in North Carolina on that issue specifically that I was able to find, but that's my suspicion. And similarly, if a promissory note doesn't qualify as a negotiable instrument and it's not governed by Article 3, then the rule may not apply in that situation either. So bottom line is it's important on the front end to understand if you have the original loan documents, and if you don't, when they were lost. The second part of reviewing the loan documents is assessing the documentation of your collateral. When it comes to personal property collateral, it's important to be cognizant of the different types of collateral that exist, including the difference between any titled and untitled equipment. Before we discuss that, however, let's review what is required to actually take collateral in the first place. The key document when taking collateral is your security agreement. You need to have a written security agreement that adequately describes your collateral, states that the security interest is being granted in the collateral, is signed by the person or entity that has the authority to grant a security interest in the collateral, and that will typically be the owner of the collateral, and value needs to be given in exchange for that granting of the security interest. So assuming you have a written security agreement that meets all of these requirements and value has been given, then the second step in taking collateral is the perfection of your security interest. And this step involves providing notice to the rest of the world that you have a security interest in this particular collateral, and that anyone who comes after you who tries to take a security interest in that collateral will be taking an interest that is junior to yours. And this is really the difference where, this is really the area where the difference between titled and untitled collateral becomes key. Titled collateral is things like vehicles, trailers, and motorized heavy equipment that travel on our public roadways, have license plates, and typically have VIN numbers. This type of equipment is considered to be titled collateral that is subject to the North Carolina Certificate of Title laws. If that is your collateral, then the only way to perfect your security interest in the collateral is to have the DMV notate your lien on the certificate of title that is issued by the DMV for that particular vehicle, trailer, or item of titled equipment. So assuming you do have a certificate of title and your lien is properly notated on it, the inquiry doesn't stop there. You want to make sure, you want to compare the name of the grantor under your security agreement to the name of the owner on the certificate of title. We frequently get loan files in where one party has signed a security agreement, but the owner listed on the certificate of title is different. Maybe the grantor under the security agreement was an LLC, but then the owner on the certificate of title is one of the members of the LLC and not the LLC itself. Maybe there are additional owners on the certificate of title that didn't sign the security agreement. Perhaps a husband and wife. If only one of them signed the security agreement, then you might have a security interest in only half of your collateral. And that might make it difficult or impossible to enforce. The next thing that you want to verify is that the VIN numbers on the certificate of title and the VIN number on the security agreement are the same. If there are differences, then and there's an argument that the security agreement identifies a different piece of collateral and is covered by the certificate of title, then an intervening bankruptcy or a lien in favor of a different creditor could defeat your security interest and you might be unperfected. All right, so moving on to untitled equipment, if the collateral that you have is not subject to a certificate of title, and it's untitled equipment, or your collateral is some other personal property, and the property is located in North Carolina, then your security interest in that property can usually be perfected by the filing of a UCC-1 financing statement with the North Carolina Secretary of State. So you'll want to make sure that you have copies of your UCC-1s. You want to confirm that they accurately describe your collateral, that they were filed with the Secretary of State, and that they remain current. UCC-1s only have a lifespan of 5 years. They have to be renewed within a 6-month period before the expiration date. And if they're not, then they go dead permanently, and they will need to be, a new UCC-1 will need to be filed, which will be subject to a different date of priority. Also, when scrutinizing the collateral description in your UCC, you want to make sure that it accurately describes your collateral, and if there are any serial numbers listed in the UCC, you want to make sure that those match the serial numbers listed on your in your security agreement. Because again, any disparity could create arguments that the two documents identify different collateral, and that could give rise to unperfection that could put you at risk in a bankruptcy scenario. So assuming you have, next slide, please. Assuming you have UCC-1s, they've been filed with Secretary of State, they remain current, you want to verify that other information on those UCCs is correct and that they've been properly filed. When it comes to UCCs, the most common mistakes we see by far are that either the debtor's name on the UCC is incorrect, or that the UCC was filed in the wrong place. And a mistake in either of these areas can be fatal and leave you unperfected. When we're talking about a UCC-1, UCC-1 requires that you identify the debtor. And we're talking about identifying the debtor and filing it in the place where the debtor is located. In this context, the name of the debtor is referring to the party that owns the collateral and signed your security agreement. Now that party might not be the same as your borrower. So and they might not even be liable individually or personally for the debt. What's important is that the debtor is the same party that executed your security agreement. When it comes to identifying the debtor on the UCC-1, it's absolutely critical that you get the name of the debtor absolutely 100% right. When it comes to registered organizations such as corporations, limited liability companies, and similar entities that are created under state law, the correct name for the debtor is the name that appears on the public organic record for the state where that debtor was created. Now, by way of example, if we're talking about a Delaware corporation that is registered and doing business in North Carolina, that debtor is still a Delaware corporation. You need to determine its correct legal name. You need to look at the records on file with the Secretary of State in Delaware, and you need to go behind the actual landing page of the Secretary of State's website and look at the actual documents that were filed that created that corporation and that state its name. And then you need to look at all the subsequent documents to see if that name has been changed, amended, or restated in a way that's different than the name that originally appeared in its articles of incorporation or its articles of organization, for example. And if there are any disparities between the name of the debtor as identified in those documents and the name of the debtor that's identified on your UCC-1, then you could have an issue, and you should definitely engage counsel immediately so they can determine whether or not you are properly perfected or if you need to file a new UCC. For individuals, the name of the debtor is a little bit more straightforward. It is the name of the individual on their most recent and unexpired driver's license or special identification card that was issued by the state of North Carolina. So if they're a North Carolina resident with a North Carolina driver's license, then the name of the debtor on the UCC1 needs to be exactly how it appears on their driver's license. If they use their full middle name on the driver's license, then you need to use the full middle name on the UCC1. If only a middle initial is used, or if it's missing, then the UCC1 could be considered misleading, and that could render you unperfected. So the names need to match. Nothing more should be added to the name, and nothing should be omitted from the name. In addition to getting the debtor's name right, you need to make sure that the UCC, actually, if you could just go backwards. In addition to getting the debtor's name right, the UCC also needs to be filed in the correct place. And in that regard, the UCC needs to be filed in the place where the debtor is located. For a debtor that's an individual, they are located in the state of their principal residence. If the debtor is a registered organization like a corporation, then they are located in the state where they were organized under the law of that particular jurisdiction. So for going back to our example of a Delaware corporation, even though it might be doing business in North Carolina and it might have filed documents with the North Carolina Secretary of State, if it is a Delaware corporation, then it is located in Delaware, and that UCC1 needs to be filed in Delaware, or else you may not be perfected. In some situations, it might be a good idea to file a UCC in multiple states, but definitely the state where the debtor is organized needs to be first and foremost. All right, next slide, please. So once you've assessed your loan documents and you make sure you know you have all of them together, your collateral documents are all correct and straight and filed in the correct place, you can start identifying and understanding any deadlines that you might have to take action. In the context of a typical loan file where you have a variety of documents, you have a promissory note, you have guarantees, you have a deed of trust maybe, and perhaps a security agreement. All of these documents are oftentimes going to be considered separate contracts that while they work together, they might all have different timelines and deadlines to take action. When it comes to your primary document, or what is typically considered to be your primary document, your promissory note, the process for determining your statute of limitations to take action on a promissory note as in North Carolina is actually quite complex, or it can be quite complex depending on the complexity of your instrument and the facts of your situation. We won't go too much into it because it's outside the scope of this discussion, but there are three variables that have bearing on your statute of limitations. The first is the type of note that you have, whether it's a demand note, a note that's payable in installments over time, or a hybrid of the two. The second variable is whether or not the note was signed under seal. Documents signed under seal in North Carolina typically have a very long 10-year statute of limitations. The third variable that has bearing on your statute of limitations is whether or not the note qualifies as a negotiable instrument. If so, then the provisions of the UCC will apply. The UCC has its own statute of limitations provisions, and those need to be consulted. Once the statute of limitations has been determined, you need to determine also when the clock started to run on that statute of limitations. And that will, again, be will depend on the terms of your instrument, and it'll depend on the facts of your particular situation. Just as one example that often isn't considered, notes that are payable on demand, the clock typically starts to run immediately if the note is not a negotiable instrument. So just to restate that, a note that is not a negotiable instrument but is generally considered to be just a contract for the payment of money, but it's payable on demand, that note the statute of limitations to sue on that note is going to start to run immediately. whether it be a 3 or a 10-year statute of limitations. And again, other documents like guarantees, deeds of trust, security agreements, all of these documents have their own statute of limitations, and you should consult with counsel about when those statute of limitations are likely to occur. All right, so the second, in most loan files, the second most significant document or remedy that you might want to know about is your deed of trust and your deadline to begin a foreclosure action. In general, in North Carolina, a lender needs to begin a foreclosure action within 10 years from the date of note maturity or the date that the note was accelerated, whichever of these dates comes first. But the facts of each case can impact the running of that statute of limitations. And so you should definitely consult with counsel. For example, if a borrower makes payments on a note after maturity or acceleration, then that can restart the statute of limitations and extend it. In addition to the statute of limitations, you also need to consider the fact that the lien of a deed of trust has an expiration date that is separate and apart from the statute of limitations. Different statutory provisions will apply depending on when that deed of trust was recorded, but oftentimes you'll be looking at an expiration date of somewhere between 15 and 35 years. That's 15 years from the date of the maturity of the note, or 35 years from the date that the instrument was recorded. And again, what provision and what deadline applies is going to depend on the terms of your instrument, and you should definitely consult with counsel. But just as sort of one cautionary tale, one example, if a deed of trust contains a maturity date, for example, if the deed of trust states in the definition of the note that this deed of trust secures a note dated July 1st, 2014, that is payable on demand, then you have a maturity date implied in that statement, and the deadline to enforce that deed of trust could have begun immediately upon the execution of that note, which means that 15 years from that date, the lien could expire unless you file documents with the Register of Deeds that extend that lien expiration date. And this lien expiration date deadline could be running independent of your statute of limitations to enforce the actual note. So you might have a note that has been extended and renewed over a period of years, and now the maturity date has extended far out beyond that 15-year period. But because the deed of trust was never modified, or there were never any documents filed with the Register of Deeds to update the record, that 15-year lien expiration deadline could run before the statute of limitations expires to enforce the note. So if you have any older deed of trusts kicking around that have maturity dates stated in them, then you want to have those. You want to review those documents and make sure that you don't have a lien expiration date approaching. And if you do, or if that date is expired, then you'll definitely want to consider workout options that might be available to you that could allow you to enter into agreement with the borrower to extend those dates. But I think Lily will talk a little bit more about that. So I'll go ahead and, I think I'm running a little bit long here. I'll go ahead and hand it over to Lily to talk about your collateral position and workout considerations based on the loan documents and the remedies that you have.
Thanks, Norman. Hi, everyone. I'm Lily Faulconer. I'm a creditor's rights attorney in the firm's Greenville office, and excited to talk with you for the next 10-15 minutes. So picking up where Norman left off, the last piece of review when you are kind of tackling your review of your documents is considering your collateral position. And so first you want to think about, is your loan adequately secured? So in addition to thinking about whether or not you have properly perfected your interest, with your UCC filings, you want to think about, have any changes occurred where maybe now you are not as secured as you were. And a good example of this is with real property collateral that may appraise at a certain amount when the file is open, when the initial loan is made, but 10 to 15 years later has maybe depreciated in value for some reason, or the appraisal was inaccurate for one reason or another. And then there may be concerns with whether or not you were adequately secured with the real property collateral that you have. Another thing to think about are whether or not there are outstanding taxes or other liabilities that might reduce your recovery, whether or not the collateral is rental property. If so, whether or not it's occupied by paying tenants. And if it is occupied by paying tenants, one, do you have an assignment of rents? Are you receiving rents, or could you receive rents pursuant to that document? Or, if you have an assignment of rents and they're paying tenants and you're supposed to be receiving rents, but you're not, you want to think about why that is and why you just discovered that issue. Another thing to think about is the credit worthiness of your guarantors. They could have had a certain level of credit worthiness when the relationship began, and that could have increased or decreased throughout the relationship. And in your current position, want to really think about whether or not you may want to add some additional guarantors, or if you have any other concerns about their credit worthiness. And so once you've thought about all of these things, you've considered your collateral position, you have reviewed your loan documents, you've thought about any deadlines that you might have to take action, you want to formulate your preferred strategies. You want to think about what is next. And so we're going to kind of lump that into 3 buckets today: forbearance, collection, and foreclosure. And so first up, of course, forbearance. And forbearance obviously involves you forbearing, choosing not to enforce your rights, perhaps giving the obligors a little more time to make payments, address any problems that you identified. And so in addition to allowing your obligors more time, you can resolve a lot of problems and perhaps also improve your position overall in a forbearance agreement. So first step, of course, is to memorialize that agreement, your agreement to forbear. You want to have drafted a comprehensive forbearance agreement. And in that, you can address any of the deficiencies, problems, or uncertainties that you kind of discovered through the process that we just walked through. Another thing that you can address in those, of course, is any kind of modifications you want to make to monthly payment amounts or quarterly payment amounts. If you want to change the schedule of payments, if you want to, change the interest rate. But you can also do a couple of things to improve your position instead of just, remedy any identified problems. And so, like we just said, if you think that you may have an issue with security, whether or not you're adequately secured, or if you'd like to add some additional guarantors just for peace of mind, a forbearance agreement is a great place to do that. You can add some additional collateral. Maybe when the relationship began, your borrower owned 1 piece of real property, now they own 3. You can add those extra 2 as collateral in your forbearance agreement, as a condition of your forbearing. Another thing to add in is default interest rates, especially if those are lacking in your initial documents. You want to go ahead and provide those rates and what they are. And then also you can add in foreclosure waivers or bankruptcy terms. And those are going to allow you to, ahead of any potential foreclosure or bankruptcy that may occur in the future, go ahead and put some terms in about how the parties will act and will agree in those situations. So an easy example of a bankruptcy term would be consent to lift of the automatic stay, so that you can continue to enforce your rights in the event of a bankruptcy. Now, these terms may not always be enforceable, but they definitely won't be enforceable if you don't put them in your document. And so it's always a good idea to have them in there so that the court can see that you and your obligor have at least contemplated what may happen in these situations, which can elevate you and provide further proof for your position in the event of a bankruptcy or a default and a subsequent foreclosure. So let's say you've gone the forbearance path and unfortunately hasn't worked, or you don't really feel the need to forbear, you feel pretty confident with your position. What do you do instead if you have a defaulting obligor? How are you going to enforce those rights? And so you can file a collections action and or file a foreclosure. And so foreclosure is only going to be applicable if you have real property collateral. But let's assume for the sake of this discussion that you have both personal property collateral and real property collateral. So you can do a number of things. You can choose, of course, just to file a foreclosure. You can choose just to file a collections action. You can also choose to file one and then the other, or both at the same time. And when you're thinking about what you'd like to do there are a couple things that you should consider. Of course, you want to consider, as we've already mentioned, your collateral position. Are you, are you secured or unsecured? Of huge importance. If you're unsecured, you're really not going to be thinking about a foreclosure because you don't really have real property to foreclose on. But if you are secured, are you in first lien position? Are you second? Are you third? Where do you add up and stack up compared to other creditors of your obligors? What attorney's fees may you recover in a foreclosure versus a collections action? And then, as Norm discussed earlier, do you have any statute of limitations issues related to your note or to your deed of trust that are going to make pursuing one and then the other or both at the same time a more favorable course of action? And so now I'm just going to break down briefly. I know you probably all know kind of the bare bones and the backbone of a collection action and a foreclosure, but just a quick recap for you because it is summer school. So in a collections action, you're going to be filing a lawsuit. You will be the plaintiff seeking from the defendant your recovery. And what you will be seeking to recover will vary, but of course you make a claim for the note balance. You can make a claim for possession of that personal property collateral. You can also simultaneously file what's called a claim in delivery. It's a little beyond the scope of today's discussion. Happy to discuss offline. Along with that claim for possession of your personal property collateral, you can file a claim for your attorney's fees, which I'll discuss in a moment in more detail. And then anything else that you're entitled to under the loan documents or anything that has arisen in the course of the relationship where you have a right that either could be enforced or a right that's been violated that you want to address in that collection action. Of course, the exception is real property collateral. You're going to handle that through your foreclosure process. A judgment in a collection action is going to create a lien on all real property owned by the judgment debtor in the county where the action was filed. So what that means is if I file a collections action in Johnston County, North Carolina, I obtain a judgment in Johnston County, then all of the real property owned by the debtor in Johnston County, my judgment lien will then attach to. If you attended our first summer school series this summer, you will remember Tyler and Thomas discussing execution strategies when you obtain judgments in collection actions. And so you'll recall that if you know that your obligors own real property in other counties, you want to go ahead and transcribe that judgment so that your liens also attach to any real property debtors own in counties outside of the county where you got the judgment. So for example, if I knew that my borrowers had real property collateral in Lee and Harnett County in addition to Johnston, I would want to transcribe that judgment to those two counties so that my lien attached to that real property. Of course, may not be first lien position, but it is at least attached to that real property owned by the obligors. And I know we're coming up short on time, so I'll just go briefly over, of course, what a foreclosure is and how it differs from a collection action. So a foreclosure is unique because it is a special proceeding in front of the clerk of court. So this is not go before a judge, it is a proceeding before the clerk. And whereas in a collections action, you just have the plaintiff and the defendant or defendants, and a foreclosure, you're going to have three parties. You're going to have the lender, the obligor, so the person who has granted the interest in that property in the deed of trust, and the trustee or the substitute trustee, who is going to be the party that initiates that foreclosure proceeding. Foreclosures in North Carolina are governed by a statutory process. And as a result of that process, foreclosures can be pretty quick. So you can have a resolution in a foreclosure typically 60 to 120 days from the filing of the notice of hearing to the sale. And just for context, in a collections action, when you file the collections action and obtain service on the defendants, they have 30 days to answer. And that 30 days may be extended another 30 days. And so then you're already at your 60-day mark where you may have a sale already occurring in a foreclosure. And of course, this doesn't happen every time. Can't guarantee that it will always move as quickly as is typical, but generally speaking, a faster process in foreclosure. And then last thing for today, I just wanted to give you all a refresher on attorney's fees. So we talked about considering what you may recover in attorney's fees when you're thinking about the kind of action that you want to pursue. And I just want to make you all aware of a recent Fourth Circuit case that analyzed North Carolina law as it relates to the recovery of reasonable attorney's fees. And so in North Carolina, our attorney's fee statute essentially has two avenues for recovery of attorney's fees. The first is if your loan documents provide a specific percentage of recovery, you will be able to recover that percentage up to not exceeding 15%. So for example, if your loan documents provided that upon default, the borrower will be responsible for your attorney's fees to 12% for your enforcement of your rights, then that would be allowed, and that would be the amount that you would recover. If your loan documents stated that upon default, the borrower would be responsible for 20% attorney's fees, that would not be enforceable because that's above that threshold of 15% for actual attorney's fees for that specific provision. The other way you can recover attorney's fees is if your loan documents say that you are entitled to reasonable attorney's fees upon default. And in this case, there was great debate about what it meant to be reasonable. And North Carolina law essentially provides that reasonable attorney's fees are 15% attorney's fees. And that is the case even if you are a borrower who has a multi-million-dollar loan upon which you default and a simple collections action is filed, and the actual attorney's fees incurred by the lender are much smaller than maybe the multi-million dollars in attorney's fees that you will consequently owe as a result of your loan documents saying reasonable attorney's fees, which equal 15% under the statute. So you really want to think about, what do your loan documents say about your attorney's fees recovery? Do you want to change the language so that you are perhaps in a more favorable position? And then how does that impact your decision about pursuing a collection action, pursuing a foreclosure, or pursuing both simultaneously? And with that, we'll take the last few minutes for questions.
All right, if you have any questions, you can drop them in the Q&A on your Zoom kind of panel bar there. And we'd be happy to answer those. All right, well, we do have one. So what, and I believe Lily, this might be for you. What if my loan documents permit recovery of attorney's fees, but do not provide a specific percentage or use of reasonable qualifier?
Right. So this is when I was talking about, assessing what your loan documents say and how you might want to change them to be more favorable. So if you have in there that you can recover attorney's fees, that's great. But you will want to make sure that you have something in there that kind of qualifies exactly what you're seeking to recover. So of course, this will be, dependent on your documents, dependent on the situation, but always a good idea to think about, do you need to add in the reasonable qualifier to hit that 15% threshold, or are you comfortable with a specific percentage? And, you may have to to file additional documents related to your actual attorney's fees if your loan documents aren't specific in those ways.
Great. Well, we do not have any other questions, and I am showing 1 o'clock. So I'm going to close this out unless Norman and Lily, do you guys have anything else?
No, thank you all so much.
Thank
I
you
do not.
guys.
Thank you very much for coming.
Yes. For those of you that are in attendance today, following this webinar, you're going to be sent an email with a recording of this session. It might take until tomorrow morning just to get onto our cloud platform, as well as all of these slides. I know we covered a lot of material, so the slides will be included as well. If you missed the first two, you can find the other two webinars on our website under the webinars tab, and then it'll link you to our YouTube channel, so you are able to go view those as well. We are so grateful for your participation, and we hope that you can utilize the knowledge you've gained today to enhance your business and organization. Thank you so much. I hope you have a great rest of your summer, and this concludes today's webinar.